Ready? Start. The trial court, after hearing the contentions of the learned counsel for the parties, passed judgment on 9/11/2017, acquitting accused from the offence under Section 377 IPC, but held him guilty for the offence under Section 5 upon 6 of POCSO Act 2012 and sentenced with rigorous imprisonment for 10 years and also fine of rupees 50,000 in default of payment of fine. The convict was also directed to undergo an additional rigorous imprisonment for 2 years. Stop. Aggrieved from the impugned judgment of conviction and sentence, this criminal appeal has been preferred on behalf of the appellant convict on the ground that the conviction of the appellant held by the trial court is against the weight of the evidence on record. Stop. The learned trial court committed manifest illegality apparent on the face of record and convicted the appellant. Stop. PW2 in her statement has narrated that she came to know in regard of occurrence from the people of village, but none of the person of the village was examined. Stop. Even no person of the village was named by his witness from whom she had come to know in regard to the occurrence. Stop. Statement of PW4 also does not corroborate the prosecution story. Stop. The trial court convicted the appellant for the offence under Section 5 upon 6 of POCSO Act on the basis of wrong finding which is not sustainable in the eye of law. Stop. Learned AGA opposed the contentions made by the learned counsel for the appellant and contended that the single testimony of PW3 is sufficient for the conviction of the appellant accused. Stop. This witness PW3 before examination by the court was also testified by the court in regard to his competency as a witness, and court, after having satisfied that this witness was competent, examined this witness. Stop. Testimony of this witness is natural, which shall be relied even if the medical evidence does not support the ocular evidence. Stop. The ocular evidence is to prevail to medical evidence, which is simply an opinion of expert. Stop. For testimony of child witness to be admissible, one condition which is to be fulfilled is that the witness should be competent. Stop. To testify the child as a competent witness, it is very necessary to testify the intellectual of the child, whether he understands the question put to him or gives rational answers to those questions. Stop. The mental development of a child witness vary in different situations depending upon the conditions he lives in and nurtured. Stop. The reasonable view is to give benefit of doubt to the convict appellant. Stop. The theory of adopting view beneficial to accused if the two views are possible. Stop. If both the views are reasonable and plausible, the reasonable view being beneficial to the accused should be adopted. Stop. As such, in view of the reappreciating of the evidence in this appeal, the conviction and sentence passed by the trial court of the appellant convict for the offence, trial court under Section 5 upon 6 of POCSO Act deserves to set aside. stop. Accordingly, this criminal appeal deserves to be allowed. Stop over.